Good evening and welcome. Today I shall be recording a full audio rendition of the English version of the Canadian Constitution. So we have here from the government's website, Constitution Acts of 1867 through until 1982. Constitution Act of 1982, Part 1, Canadian Charter of Rights and Freedoms. Whereas Canada is founded upon principles that recognize the supremacy of God and the rule of law. Guarantee of rights and freedoms. Rights and freedoms in Canada. Article 1. The Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it, subject only to such reasonable limits as are prescribed by law and can be demonstrably justified in a free and democratic society. Fundamental freedoms. Again, fundamental freedoms. Article 2. Everyone has the following fundamental freedoms. Article 2, subsection A. Freedom of conscience and religion. Article 2, subsection B. Freedom of thought, belief, opinion, and expression, including freedom of the press and other media of communication. Article 2C. Freedom of peaceful assembly, and Article 2D. Freedom of association. Democratic rights. The democratic rights of citizens. Article 3. Every citizen of Canada has the right to vote in an election of members of the House of Commons or of a legislative assembly and to be qualified for membership therein. Maximum duration of legislative bodies. Article 4, Section 1. No House of Commons and no legislative assembly shall continue for longer than 5 years from the date fixed for the return of the writs at a general election of its members, in brackets 81. And I do believe that that would actually send me to a link, and when I hover my cursor over it, it is listed as being footnote 81. Continuation in special circumstances. Article 4, subsection 2. In times of real or apprehended war, invasion or insurrection, a House of Commons may be continued by Parliament and a legislative assembly may be continued by the legislature beyond 5 years, if such continuation is not opposed by the votes of more than 1/3 of the members of the House of Commons or the legislative assembly, as the case may be. We have here another hyperlink, which would take me to footnote 82. Annual sitting of legislative bodies. There shall be a sitting of Parliament and of each legislature at least once every 12 months. We have here another hyperlink to footnote 83. Mobility rights. Mobility of citizens. Article 6, subsection 1. Every citizen of Canada has the right to enter, remain in, and leave Canada. Right to move and gain livelihood. Article 6, subsection 2. Every citizen of Canada and every person who has the status of a permanent resident of Canada has the right to, Article 6, subsection 2A, to move to and take up residence in any province, and Article 6, subsection 2b, to pursue the gaining of a livelihood in any province. Limitation. Article 6, subsection 3. The rights specified in subsection 2 are subject to Article 6, subsection 3a, any laws or practices of general application in force in a province other than those that discriminate among persons primarily on the basis of province of present or previous residence, and Article 6, subsection 3b, any laws providing for reasonable residency requirements as a qualification for the receipt of publicly provided social services. Article 6, subsection 4. Subsections 2 and 3 do not preclude any law, program, or activity that has that has as its object the amelioration in a province of conditions of individuals in that province who are socially or economically disadvantaged if the rate of employment in that province is below the rate of employment in Canada. Legal rights: life, liberty, and security of the person. Article 7. Everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof, except in accordance with the principles of fundamental justice. Search or seizure. Article 8. Everyone has the right to be secure against unreasonable search or seizure. Detention or imprisonment. Article 9. Everyone has the right not to be arbitrarily detained or imprisoned. Arrest or detention. Article 10. Everyone has the right on arrest or detention to Article 10, subsection A, to be informed promptly of the reasons therefor. Article 10, subsection B, to retain and instruct counsel without delay and be informed of that right. And Article 10, subsection C, to have the validity of the detention determined by way of habeas corpus and to be released if the detention is unlawful. Proceedings in criminal and penal matters. Article 11. Any person charged with an offense has the right to, Article 11, subsection A, to be informed without unreasonable delay of the specific offense, Article 11, subsection B, to be tried within a reasonable period of time. Article 11, subsection C, to not be compelled to be a witness in proceedings against that person in respect to the offense. Article 11, subsection D, to be presumed innocent until proven guilty according to law in a fair and public hearing by an independent and impartial tribunal. Article 11, subsection E, not to be denied reasonable bail without just cause. Article 11, subsection F, except in such cases of offense under military law tried before a military tribunal to the benefit of trial by jury, where the maximum punishment for the offense is imprisonment for 5 years or a more severe punishment. Article 11, subsection G, not to be found guilty on account of any act or omission, unless, at the time of the act or omission, it constituted an offense under Canadian or international law, or was criminal according to the general principles of law recognized by the community of nations. Article 11, subsection H, if finally acquitted of the offense, not to be tried for it again, and if finally found guilty and punished for the offense, not to be tried or punished for it again. So double jeopardy, basically. And Article 11, subsection I, if found guilty of the offense and if the punishment for the offense has been varied between the time of commission and the time of sentencing to the benefit of the lesser punishment. Treatment or punishment. Article 12. Everyone has the right not to be subjected to any cruel and unusual treatment or punishment. Article 13. Self-incrimination. A witness who testifies in any proceedings has the right not to have any incriminating evidence so given used to incriminate that witness in any other proceedings, except in a prosecution for perjury or for the giving of contradictory evidence. Interpreter. Article 14. A party or witness in any proceedings who does not understand or speak the language in which the proceedings are conducted or who is deaf has the right to the assistance of an interpreter. Equality rights. Equality before and under law and equal protection and benefit of law. Article 15, subsection 1. Every individual is equal before and under the law and has the right to the equal protection and equal benefit of the law without discrimination and, in particular, without discrimination based on race, national or ethnic origin, skin color, religion, sex, age, or mental or physical disability. Affirmative action programs. Article 15, subsection 2. Subsection 1 does not preclude any law, program, or activity that has as its object the amelioration of conditions of disadvantaged individuals or groups, including those that are disadvantaged because of race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. We have here a hyperlink to footnote 84, which I will not be reading. Official languages of Canada. Official languages of Canada. Article 16, subsection 1. English and French are the official languages of Canada and have equality of status and equal rights and privileges as to their use in all institutions of the Parliament and Government of Canada. Official languages of New Brunswick. Article 16, subsection 2. English and French are the official languages of New Brunswick and have equality of status and equal rights and privileges as to their use in all institutions of the legislature and government of New Brunswick. Advancement of status and use. Article 16, subsection 3. Nothing in this charter limits the authority of Parliament or a legislature to advance the equality of status or use of English and French. I find it rather odd that they have a section specifically naming New Brunswick. I can only venture a guess as to why, but perhaps that's because they entered Confederation later and they thought it was worthy of note. Interesting. English and French linguistic communities in New Brunswick. Article 16.1, subsection 1. The English linguistic community and the French linguistic community in New Brunswick have equality of status and equal rights and privileges, including the right to distinct educational institutions and such distinct cultural institutions as are necessary for the preservation and promotion of those communities. Role of the Legislature and Government of New Brunswick. Article 16.1, subsection 2. The role of the Legislature and Government of New Brunswick to preserve and promote the status, rights, and privileges referred to in subsection 1 is affirmed. And we have here a hyperlink to footnote 85. Proceedings of Parliament. Article 17, subsection 1. Everyone has the right to use English or French in any debates and other proceedings of Parliament. And here is a hyperlink to footnote 86. Proceedings of New Brunswick Legislature. Article 17, subsection 2. Everyone has the right to use English or French in any debates and other proceedings of the Legislature of New Brunswick. Here we have a footnote to footnote 87. Parliamentary Statutes and Records. Article 18, subsection 1. The statutes, records, and journals of Parliament shall be printed and published in English and French, and both language versions are equally authoritative. We have here a link to footnote 88. Interesting to note that if there is any sort of discrepancy due to the translation between the English and French versions of the law, you can often take advantage of that by citing the Constitution in the preferred language that gives you an edge. So ideally things would translate perfectly, but they rarely ever do. So that is one thing that can be used to benefit someone in a legal case if they manage to find such a loophole. Continuing. New Brunswick Statutes and Records. Article 18, subsection 2. The statutes, records, and journals of the Legislature of New Brunswick shall be printed and published in English and French, and both language versions are equally authoritative. We have here a link to footnote 89. Proceedings in courts established by Parliament. Article 19, subsection 1. Either English or French may be used by any person in any pleading in or process issuing form, any court established by Parliament. I'm going to reread that, but the way it's phrased is rather odd. Either English or French may be used by any person in, or in any pleading in, or processing issues from any court established by Parliament. It appears that there's some commas missing in that sentence, which is why it was rather more difficult to read than it should have been. At the base of that, there's a link to footnote 90. Continuing. Proceedings in New Brunswick courts. Article 19, subsection 2. Either English or French may be used by any person in, or in any pleading in, or process issuings from any court of New Brunswick. This is followed by a link to footnote 91. Communications by public with federal institutions. Article 20, subsection 1. Any member of the public in Canada has the right to communicate with and to receive available services from any head or central office of any institution of the Parliament or Government of Canada in English or French, and has the same right with respect to any other office of any such institution where, Article 20, subsection 1a, there is a significant demand for communications with the services with and services from that office in such language, or Article 20, subsection 1b, due to the nature of the office, it is reasonable that communications with and services from that office be available in both English and French. Communications by public with New Brunswick institutions. Article 20, subsection 2. Any members of the public in New Brunswick has the right to communicate with and to receive available services from any office of any institution of the legislature or government of New Brunswick in English or French. Continuation of existing constitutional provisions. Article 21. Nothing in sections 16 to 20 abrogates or derogates from any right, privilege, or obligation with respect to the English and French languages, or either of them, that exists or is continued by virtue of any other provision of the Constitution of Canada. We have here a link to footnote 92. Rights and privileges preserved. Article 22. Nothing in sections 16 to 20 abrogates or derogates from any legal or customary right or privilege acquired or enjoyed either before or after the coming into force of this charter with respect to any language that is not English or French. Continuing. Minority language educational rights. Language of instruction. Article 23, subsection 1. Citizens of Canada. Article 23, subsection 1a. Those whose first language learned and still understood is that of English or French linguistic minority population of the province in which they reside, or, Article 23, subsection 1b, who have received their primary school instruction in Canada in English or French and reside in a province where the language in which they received that instruction is the language of the English or French linguistic minority population of the province, have the right to have their children receive primary and secondary school instruction in that language in that province. And we have here footnote 93. And I do believe the reason for that was due to fears of French independence movements in Quebec. People didn't exactly take to Confederation all that well initially. They wanted to make sure that their best interests were protected. Continuity of language instruction. Article 23, subsection 2. Citizens of Canada of whom any child has received or is receiving primary or secondary school instruction in English or French in Canada have the right to have all their children receive primary and secondary school instruction in the same language. Article 23, subsection 3, heading Applications where numbers warrant. the right of citizens of Canada under subsections 1 and 2 of Article 23 to have their children receive primary and secondary school instruction in the language of the English or French linguistic minority population of a province, Article 23, subsection 3a, applies wherever in the province the number of children of citizens who have such a right is sufficient to warrant the provision to them out of public funds of minority language instruction, and Article 23, subsection 3b, includes where the number of those children so warrants the right to have them receive that instruction in minority language educational facilities provided out of public funds. Enforcement. Enforcement of guaranteed rights and freedoms. Article 24, subsection 1. Anyone whose rights or freedoms, as guaranteed by this charter, have been infringed or denied may apply to a court of competent jurisdiction to obtain such remedy as the court considers appropriate and just in the circumstances. Exclusion of evidence bringing administration of justice into dispute. Article 24, subsection 2. Where in the proceedings under subsection 1, a court concludes that evidence was obtained in a manner that infringed or denied any rights or freedoms guaranteed by this charter, the evidence shall be excluded if it is established that, having regard to all the circumstances, the admission of it in the proceedings would bring the administration of justice into dispute. General. Aboriginal rights and freedoms not affected by the Charter. Article 25. The guarantee in this Charter of certain rights and freedoms shall not be construed so as to abrogate or derogate from any Aboriginal treaty or other rights or freedoms that pertain to the Aboriginal peoples of Canada, including Article 25, subsection A. Any rights or freedoms that have been recognized by the Royal Proclamation of October 7, 1763, and Article 25, subsection B, any rights or freedoms that now exist by way of land claims agreements or may be so acquired. We have a link here to footnote 94. Other rights and freedoms not affected by the Charter. Article 26. The guarantees in this Charter of certain rights and freedoms shall not be construed as denying the existence of any other rights or freedoms that exist in Canada. Multicultural heritage. Article 27. This Charter shall be interpreted in a manner consistent with the preservation and enhancement of the multicultural heritage of Canadians. Rights guaranteed equally to both sexes. Article 28. Notwithstanding anything in this Charter, the rights and freedoms referred to in it are guaranteed equally to male and female persons. Rights respecting certain schools preserved. Article 29. Nothing in this Charter abrogates or derogates from any rights or privileges guaranteed by or under the Constitution of Canada in respect of denominational, separate, or dissentient schools. And we have here a link to footnote 95. Application to territories and territorial authorities. Article 30. A reference in this Charter to a province or to the Legislative Assembly or legislature of a province shall be deemed to include a reference to the Yukon Territory and the Northwest Territories or to the appropriate legislative authority thereof, as the case may be. Legislative powers not extended. Article 31. Nothing in this Charter extends the legislative powers of any body or authority. Application of Charter. Application of Charter. Article 31, subsection 1. This Charter applies to Article 32, subsection 1a, to the Parliament and Government of Canada in respect of all matters within the authority of Parliament, including all matters relating to the Yukon Territory and Northwest Territories, and Article 32, subsection 1b, to the legislature and government of each province in respect of all matters within the authority of the legislature of each province. Exception. Article 32, subsection 2. Notwithstanding subsection 1, section 15 shall not have any effect until 3 years after this section comes into force. Exception where express declaration. Article 33, subsection 1. Parliament or the legislature of a province may expressly declare in an act of Parliament or of the legislature, as the case may be, that the act or a provision thereof shall operate notwithstanding a provision included in Section 2 or Sections 7 through 15 of this Charter. That's an important note there. It's considered to be the quote-unquote notwithstanding clause of the Constitution, which means large portions of it can basically be ignored and the government can still pass laws that violate the Constitution using the notwithstanding clause. It's basically one of those things that they could use, but they rarely ever do, because being the democracy that we are, justifying its use could be somewhat tenuous depending on who you are and what the populace actually thinks. So if you try and propose something that's flagrantly unconstitutional, you can get away with it, but you better back it up. Anyway, I forget exactly where we were, so I'll just restart with Article 33, subsection 1. Parliament or the legislature of a province may expressly declare in an act of Parliament or of the legislature, as the case may be, that the act or a provision thereof shall operate notwithstanding a provision included in Section 2 or Sections 7 through 15 of this Charter. Operation of exception. Article 33, subsection 2. An act or a provision of an act in respect of which a declaration made under this section is in effect shall have such operation as it would have but for the provision of this Charter referred to in the declaration. 5-year limitation. Article 33, subsection 3. A declaration made under subsection 1 shall cease to have effect 5 years after it comes into force or on such earlier date as may be specified in the declaration. Reenactment. Article 33, subsection 4. Parliament or the legislature of a province may reenact a declaration made under subsection 1. 5-year limitation. Article 33, subsection 5. Subsections 3 applies in respect of a reenactment made under subsection 4. Citation. Article 34. This part may be cited as the Canadian Charter of Rights and Freedoms. So that concludes the first portion of the Constitution. Next we have Part 2. Rights of the Aboriginal Peoples of Canada. Recognition of existing Aboriginal and treaty rights. Article 35, subsection 1. The existing Aboriginal and treaty rights of the Aboriginal Peoples of Canada are hereby recognized and affirmed. Definition of Aboriginal Peoples of Canada. Article 35, subsection 2. In this Act, Aboriginal Peoples of Canada includes the Indian, Inuit, and Métis Peoples of Canada. Land Claims Agreements. Article 35, subsection 3. For greater certainty, in subsection 1, treaty rights includes rights that now exist by way of land claims agreements or may be so acquired. Aboriginal and treaty rights are guaranteed equally to both sexes. Article 35, subsection 4. Notwithstanding any other provisions of this Act, the Aboriginal and treaty rights referred to in subsection 1 are guaranteed equally to male and female persons. We have here a hyperlink to footnote 96. Also, going back to Article 35, subsection 3, and the heading to Article 35, subsection 4, it says Aboriginal and treaty rights are guaranteed equally to both sexes. Therefore, Canadian Constitution confirms there's only two genders. Beautiful. Very funny. Anyway, and somewhat ironic as well, considering that most of these particular sections are put in place specifically to try and recognize so-called disaffected or oppressed groups. Anyway, continuing. Commitment to participation in constitutional conference. Article 35.1. The Government of Canada and the provincial governments are committed to the principle that, before any amendment is made to Class 24 of Section 91 of the Constitution Act circa 1867 to Section 25 of this Act, or to this part, Article 35.1a, a constitutional conference that includes in its agenda an item relating to the proposed amendment, composed of the Prime Minister of Canada and the First Ministers of the provinces, shall be convened by the Prime Minister of Canada and, Article 35.1, subsection B, the Prime Minister of Canada will invite representatives of the Aboriginal peoples of Canada to participate in the discussions of that item. We have here footnote 97. Part 3. Equalization and regional disparities. Commitment to promote equal opportunities. Article 36, subsection 1. Without altering the legislative authority of Parliament or of the provincial legislatures or the rights of any of them with respect to the exercise of their legislative authority, Parliament and the legislatures, together with the Government of Canada and the provincial governments, are committed to, Article 36, subsection 1a, promoting equal opportunities for the well-being of Canadians, Article 36, subsection 1b, furthering economic development to reduce disparity in opportunities, and Article 36, subsection 1c, providing essential public services of reasonable quality to all Canadians. Commitment and respecting public services. Article 36, subsection 2. Parliament and the Government of Canada are committed to the principle of making equalization payments to ensure that provincial governments have sufficient revenues to provide reasonably comparable levels of public services at reasonably comparable levels of taxation. We have here footnote 98 in reference to that. Part 4. Constitutional Conference. Article 37, we have in brackets here repealed, and we have a link to footnote 99. Part 4.1, Constitutional Conferences. Here we have Article 37.1, and it's marked repealed with a link to footnote 100. And we have next Part 5, Procedure for Amending the Constitution of Canada, with a link to footnote 101. General Procedure for Amending the Constitution of Canada. Article 38, subsection 1. An amendment to the Constitution of Canada may be made by proclamation issued by the Governor-General under the Great Seal of Canada, where so authorized by Article 38, subsection 1a, resolutions of the Senate and House of Commons, and Article 38, subsection 1b, resolutions of the legislative assemblies of at least 2/3 of the provinces that have, in the aggregate, according to the then latest general census, at least 50% of the population of all the provinces. Majority of members. Article 38, subsection 2. An amendment made under subsection 1 that derogates from the legislative powers the proprietary rights of any other rights or privileges of the legislature or government of a province shall require a resolution supported by a majority of the members of each of the Senate, the House of Commons, and the legislative assemblies required under subsection 1. Expression of dissent. Article 38, subsection 3. An amendment referred to in subsection 2 shall not have effect in a province the legislative assembly of which has expressed its dissent thereto by resolution supported by a majority of its members prior to the issue of the proclamation to which the amendment relates, unless that legislative assembly subsequently by resolution supported by a majority of its members revokes its dissent and authorizes the amendment. Revocation of dissent. Article 38, subsection 4. A resolution of dissent made for the purposes of subsection 3 may be revoked at any time before or after the issue of the proclamation to which it relates. Restriction on proclamation. Article 39, subsection 1. A proclamation shall not be issued under subsection 38-1 before the expiration of 1 year from the adoption of the resolution initiating the amendment procedure thereunder, unless the Legislative Assembly of each province has previously adopted a resolution of assent or dissent. Idem. Article 39, subsection 2. A proclamation shall not be issued under subsection 38(1) after the expiration of 3 years from the adoption of the resolution initiating the amendment procedure thereunder. Compensation. Article 40. Where an amendment is made under subsection 38-1 that transfers provincial legislative powers relating to education or other cultural matters from provincial legislature to Parliament, Canada shall provide reasonable compensation to any province to which the amendment does not apply. Amendment by unanimous consent. Article 41. An amendment to the Constitution of Canada in relation to the following matters may be made by proclamations issued by the Governor-General under the Great Seal of Canada only where authorized by resolutions of the Senate and House of Commons and of the Legislative Assembly of each province. Article 41, subsection A. The office of the Queen, the Governor-General, and the Lieutenant Governor of a province. Article 41B. The right of a province to a number of members in the House of Commons not less than the number of senators by which the province is entitled to be represented at the time this part comes into force. Article 41, subsection C. Subject to section 43, the use of the English or the French language. Article 41, subsection D. The composition of the Supreme Court of Canada, and Article 41, subsection E, and amendment to this part. Amendment by general procedure. Article 42, subsection 1, and amendment to the Constitution of Canada in relation to the following matters may be made only in accordance with subsection 38(1). Section 42, subsection 1A. The principle of proportionate representation of the provinces in the House of Commons prescribed by the Constitution of Canada, Article 42, subsection 1B. The powers of the Senate and the method of selecting senators. Article 42, subsection 1C. The number of members by which a province is entitled to be represented in the Senate and the residence qualifications of senators. Article 42, subsection 1D. Subject to paragraph 41D, the Supreme Court of Canada. Article 42, subsection 1E. The extension of existing provinces into the territories, and Article 42, subsection 1F. Notwithstanding any other law or practice, the establishment of new provinces. Exception. Article 42, subsection 2. Subsection 38(2) through 38(4) do not apply in respect of amendments in relation to matters referred to in subsection 1. Amendment of provisions relating to some but not all provinces. Article 43. An amendment to the Constitution of Canada in relation to any provision that applies to one or more, but not all, provinces, including Article 43, subsection A. Any alteration to boundaries between provinces, and Article 43, subsection B. Any amendments to any provision that relates to the use of the English or the French language within a province. Both may be made by proclamation issued by the Governor-General under the Great Seal of Canada only where so authorized by resolutions of the Senate and House of Commons and of the Legislative Assembly of each province to which the amendment applies. Amendment by Parliament. Article 44. Subject to sections 41 and 42, Parliament may exclusively make laws amending the Constitution of Canada in relation to the executive government of Canada or the Senate and House of Commons. Amendments by provincial legislatures. Article 45. Subject to Section 41, the legislature of each province may exclusively make laws amending the constitution of the province. Initiation of amendment procedures. Article 46, subsection 1. The procedures for amendment under sections 38, 41, 42, and 43 may be initiated either by the Senate or the House of Commons or by the Legislative Assembly of a province. Revocation of authorization. Article 46, subsection 2. A resolution of assembly made for the purposes of this part may be revoked at any time before the issue of a proclamation authorized by it. Amendments without Senate resolution. Article 47. Article 47, Part 1. An amendment to the Constitution of Canada made by proclamation under Section 38, 41, 42, or 43 may be made without a resolution of the Senate authorizing the issue of the proclamation if within 180 days after the adoption by the House of Commons of a resolution authorizing its issue, the Senate has not adopted such a resolution, and if at any time after the expiration of that period, the House of Commons again adopts the resolution. Computation of period. Article 47, subsection 2. Any period when Parliament is prorogued or dissolved shall not be counted in computing the 180-day period referred to in subsection 1. Advice to issue proclamation. Article 48. The Queen's Privy Council for Canada shall advise the Governor-General to issue a proclamation under this part forthwith on the adoption of the resolutions required for an amendment made by proclamation under this part. Constitutional Conference. Article 49. A constitutional conference composed of the Prime Minister of Canada and the First Ministers of the provinces shall be convened by the Prime Minister of Canada within 15 years after this part comes into force to review the provisions of this part. We have here a link to footnote 102. Part 6. Amendment to the Constitution Act of 1867. Article 50 leaves us with nothing but a footnote to footnote 103, and Article 51 leaves us nothing save for a footnote to footnote 104, meaning those may have been moved or muddled with at some point and are no longer included within the Constitution, evidently. Continuing. Part 7. General, it just says general, so I guess that means like general notes or something to that effect. Primacy of Constitution of Canada. Article 52, subsection 1. The Constitution of Canada is the supreme law of Canada, and any law that is inconsistent with the provisions of the Constitution is, to the extent of the inconsistency, of no force or effect. Constitution of Canada. Article 52, subsection 2. The Constitution of Canada includes Article 52, subsection 2A, the Canada Act of 1982, including this Act. Article 52, subsection 2B, the acts and orders referred to in the schedule, and Article 52, subsection 2C, any amendment to any act or order referred to in paragraph A or B. Amendments to Constitution of Canada. Article 52, subsection 3. Amendments to the Constitution of Canada shall be made only in accordance with the authority contained in the Constitution of Canada. Repeals and new names. Article 53, subsection 1. The enactments referred to in column 1 of the schedule are hereby repealed or amended to the extent indicated in column 2 thereof, and, unless repealed, shall continue as law in Canada under the names set out in column 3 thereof. Consequential amendments. Article 53, subsection 2. Every enactment except the Canada Act of 1982 that refers to an enactment referred to in the schedule by the name in column 1 thereof is hereby amended by substituting for that name the corresponding name in column 3 thereof, and any British North America Act not referred to in the schedule may be cited as the Constitution Act, followed by the year and number, if any, of its enactment. Repeal and consequential amendments. Article 54. Part 4 is repealed on the day that is 1 year after this part comes into force, and this section may be repealed and this act renumbered consequentially upon the repeal of Part 4 and this section by proclamation issued by the Governor-General under the Great Seal of Canada. We have here footnote 105. Article 54.1. Repealed, and we have a link to footnote 106. French version of Constitution of Canada. Article 55. A French version of the portions of the Constitution of Canada referred to in the schedule shall be prepared by the Minister of Justice of Canada as expeditiously as possible, and, when any portion thereof sufficient to warrant action being taken has been so prepared, it shall be put forward for enactment by proclamation issued by the Governor-General under the Great Seal of Canada, pursuant to the procedure then applicable to an amendment of the same provisions of the Constitution of Canada. We have in brackets footnote 107. English and French versions of certain constitutional texts. Article 56. Where any portion of the Constitution of Canada has been or is enacted in English and French, or where a French version of any portion of the Constitution is enacted pursuant to Section 55, the English and French versions of that portion of the Constitution are equally authoritative. English and French versions of this Act. Article 57. The English and French versions of this Act are equally authoritative. Commencement. Article 58. Subject to Section 59, this Act shall come into force on a day to be fixed by proclamation issued by the Queen or the Governor-General under the Great Seal of Canada. We have here a link to footnote 108. Commencement of paragraph 23, subsection 1A, in respect of Quebec. Article 59, subsection 1. Paragraph 23, subsection 1A, shall come into force in respect of Quebec on a day to be fixed by proclamation issued by the Queen or the Governor-General under the Great Seal of Canada. Authorization of Quebec. Article 59, subsection 2. A proclamation under subsection 1 shall be issued only where authorized by the Legislative Assembly or Government of Quebec. We have here in brackets footnote 109. Repeal of this section. Article 59, subsection 3. This section may be repealed on the day paragraph 23, subsection 1A comes into force in respect of Quebec, and this Act amended and renumbered, consequentially upon the repeal of this section by proclamation issued by the Queen or the Governor-General under the Great Seal of Canada. Short title and citations. Article 60. This Act may be cited as the Constitution Act of 1982 and the Constitution Acts of 1867 to 1975, in brackets number 2, and this Act may be cited together as the Constitution Acts of 1867 to 1982. References. Article 61. A reference to the Constitution Acts of 1867 to 1982 shall be deemed to include a reference to the Constitution Amendment Proclamation of 1983. Here we have a link to footnote 110. Now on the next page, the schedule to the Constitution Act of 1982, in brackets section 53. Modernization of the Constitution. So this is broken into a series of headings that are numbered as well as 3 separate columns. And I will read this in the most logical order I can muster. Column 1, Act Affected. Item 1. British North America Act of 1867. 30-31 Vict, so that'd be Queen Victoria, C3 in brackets UK. Column 2, Amendment. So item 1, subsection 1, it reads, Section 1 is repealed and the following substituted therefore. 1. This act may be cited as the Constitution Act 1867. 2. Section 20 is repealed. 3. Class 1 of Section 91 is repealed. And lastly, 4. Class 1 of Section 92 is repealed. Column 3, new name, and we have item 1, column 3, Constitution Act 1867. Column 1, item 2, an act to amend and constitute the Act 32-33, Victoria, Chapter 3, and to establish and provide for the government of the province of Manitoba, 1870, 33 Victoria, C3 in brackets can for Canada. And now for column 2, amendment, item 2, subsection 1, the long title is repealed and the following substituted therefore. Manitoba Act 1870. Column 2, item 2, subsection 2, section 20 is repealed. Column 3, item 2, Manitoba Act 1870. Column 1, item 3, Order of Her Majesty in Council admitting Rupert's Land and the Northwestern Territory into the Union, dated the 23rd day of June, 1870. Column 2, amendment, leaves nothing. It is simply blank. Except for and then that leaves us with column 3, the new name. So column 3, item 3, Rupert's Land and Northwestern Territory, order, British Columbia. Terribly sorry, I read into the next section. Column 1, item 4, Order of Her Majesty in Council admitting British Columbia into the Union, dated the 16th day of May, 1871. Column 2 is empty, which leaves us with column 3, item 3, the new name of the act is simply British Columbia. Column 1, item 5, British North America Act 1871, sections 34-35, Victoria, C28, United Kingdom. Column 2, amendment for item 5 lists the following. Section 1 is repealed and the following substituted therefore. Quote, 1. This act may be cited as the Constitution Act 1871. And for column 3, the new name of item 5 is Constitution Act of 1871. Column 1, item 6, Order of Her Majesty in Council admitting Prince Edward Island into the Union, dated the 26th day of June, 1873. Column 2 is blank, which leaves us with column 3, the new name of the territory listed as Prince Edward Island, Terms of Union. Column 1, item 7, Parliament of Canada Act 1875, sections 38-39, Victoria C38, United Kingdom. Column 2 is blank, which leaves us with column 3, item 7, Parliament of Canada Act 1875. Column 1, item 8, Order of Her Majesty in Council admitting all British possessions and territories in North America and islands adjacent thereto into the Union, dated the 31st day of July, 1880. Column 2 is blank, which leaves us with column 3, item 8, Adjacent Territories Order. Column 1, item 9, British North America Act 1886, 49-50, Victoria C35, United Kingdom. In column 2, we have the following. Section 3 is repealed and following substituted therefore. Quote, 3. This act may be cited as the Constitution Act 1886. In column 3, for item 9, we have the new name listing Constitution Act 1886. Column 1, item 10, Canada, in brackets, Ontario Boundary, Act of 1889, 52-53, Victoria, C28, United Kingdom. Column 2 is blank, leaving us with the new name in column 3 as column 3, item 10, Canada, Ontario Boundary Act of 1889. Column 1, item 11, Canadian Speaker, Appointment of Deputy Act, 1895, Second Session, 59 Victoria C3, United Kingdom. In column 2, we have the following. The act is repealed. In column 3, it appears to be blank, nothing is listed. However, the margins do leave that somewhat unclear, at least at first glance. Column 1, item 12. The Alberta Act, 1905, 4-5, Edward the 7th, C3, Canada. Column 2 is empty, which leaves us with column 3, item 12, the Alberta Act. Column 1, item 13, the Saskatchewan Act, 1905, 4-5, Edward the 7th, C42, Canada. Column 2 is blank, leaving us with it's either the Alberta or Saskatchewan Act. I can't remember whether it was on item 12 or item 13. Presuming that to have been item 12, that would make that the Alberta Act. Column 1, item 13, the Saskatchewan Act, 1905, 4-5, Edward the 7th, C42, Canada. Column 2, blank. Column 3, Saskatchewan Act. Column 1, item 14, British North America Act, 1907, 7 Edward the 7th, C11, United Kingdom. In column 2, we have the following. Section 2 is repealed and the following substituted therefore. Quote, this act may be cited as the Constitution Act of 1907. And sure enough, column 3, item 14, we have the Constitution Act of 1907. Column 1, item 15, British North America Act, 1915, 5-6, King George V, C45, United Kingdom. Section 3 is repealed and the following substituted therefore. Quote, this act may be cited as the Constitution Act of 1915. And thus, column 3, item 15, Constitution Act 1915. Column 1, item 16, British North America Act of 1930, 20-21, King George V, C26, United Kingdom. Section 3 is repealed and the following substituted therefore. 3. This act may be cited as the Constitution Act of 1930. And therefore, column 3, item 16, Constitution Act 1930. Column 1, item 17, Statute of Westminster, 1931, 22, King George V, C4, United Kingdom. Insofar as they apply to Canada, A. Section 4 is repealed, and column 2, item 17B, subsection 7-1 is repealed. Column 3, item 17, the Statute of Westminster, or Statute of Westminster, depending on your pronunciation. Column 1, item 18, British North America Act of 1940, 3-4, George the 6th, C36, United Kingdom. Section 2 is repealed and the following substituted therefore. Quote, 2. This act may be cited as the Constitution Act 1940. Column 3, item 18, Constitution Act 1940. Column 1, item 19, British North America Act 1943, 6-7, King George VI, C30, United Kingdom. In column 2, we have the following. The act is repealed. Column 3 is empty. Column 1, item 20. British North America Act, 1946, 9-10, George VI, C-63, United Kingdom. In column 2, it states, the act is repealed. Item 21, column 1, British North America Act, 1949, 12-13, King George VI, C-22, United Kingdom. In column 2, item 21, section 3 is repealed and the following substituted therefore, quote, this act may be cited as the Newfoundland Act. Column 3, item 21, Newfoundland Act. Column 1, item 22, British North America No. 2 Act of 1949, 13, George VI, C-81, United Kingdom. In column 2, it reads, the act is repealed. Item 23, column 1, British North America Act of 1951, 14-15, King George VI, C-32, United Kingdom. The act is repealed. Column 1, item 24, British North America Act of 1952, 1, Elizabeth II, C-15, in brackets, Canada. The act is repealed. Column 1, item 25, British North America Act of 1960, 9, Elizabeth II, C-2, United Kingdom. In column 2 of item 25, section 2 is repealed and the following substituted therefore, quote, this act may be cited as the Constitution Act of 1960. Sure enough, column 3, item 25, Constitution Act 1960. Column 1, item 26, British North America Act of 1964, 12-13, Elizabeth II, C-73, United Kingdom. In column 2, section 2 is repealed and the following substituted therefore, quote, this act may be cited as the Constitution Act of 1964. In column 3, item 26, Constitution Act 1964. Column 1, item 27, British North America Act of 1965. 14, Queen Elizabeth II, C4, Part 1, in brackets, Canada. Column 2, item 27, section 2 is repealed and the following substituted therefore. 2. This part may be cited as the Constitution Act of 1965. In column 3, item 27, Constitution Act 1965. Column 1, item 28, British North America Act 1974. 23, Queen Elizabeth II, C-13, Part 1, in brackets, Canada. Column 2, item 28, Section 3 as amended by 25-26, Elizabeth II, C-28, S-38-1, Canada, is repealed, and the following substituted therefore, quote, 3. This part may be cited as the Constitution Act of 1974. Column 3, item 28, Constitution Act 1974. Item 29, column 1, British North America Act of 1975, 23-24, Queen Elizabeth II, C-28, Part 1, Canada. Column 2, item 29, Section 3 as amended by 25-26, Elizabeth II, C-28, S-31, Canada, is repealed and the following substituted therefore, quote, 3. This part may be cited as the Constitution Act No. 1 of 1975. Column 3, item 29, Constitution Act No. 1, 1975. Column 1, item 30, British North America Act No. 2, 1975, 23-24, Queen Elizabeth II, Long May She Reign, C-53, in brackets, Canada. Column 2, item 30, Section 3 is repealed and the following substituted therefore, quote, 3. This act may be cited as the Constitution Act No. 2 of 1975. Column 3, Item 30, Constitution Act No. 2 of 1975. This ends this page, and if I click the button on to the next page, we have the final page of the Constitution, and section, perhaps, is probably broken into multiple pages on the non-digital version. Nonetheless, here we have all the notes regarding the various things which were skipped at the earlier when it said it had like a footnote, which was then pushed all the way to the back, and you would have a hyperlink to it. That is what this page is dedicated to. Ideally, I would assume on the print version, the footnotes, rather than being pressed to the very back, would have been placed at the base of each page on the text. However, due to digital reformatting, such is not the case here, which may lead to some confusion in trying to follow what they refer to when viewing and listening to this digital recording. Nonetheless, we'll read it as written in the order provided on the government's own website. Whether it makes sense to have it formatted this way or not, that's what our government has deigned to do, and therefore we shall read it as written. Okay, continuing. Notes. Note 1. The enacting clause was repealed by the Statute Law Revision Act of 1893, 56-57, Queen Victoria, C14, United Kingdom. It reads as follows. Be it therefore enacted and declared by the Queen's most excellent Majesty, by and with the advice and consent of the Lords Spiritual and Temporal and Commons in this present Parliament assembled, and by the authority of the same as follows. Note 2. As amended by the Constitution Act of 1982, which came into force on April 17, 1982, this section originally read as follows. Note 2, Subsection 1. This act may be cited as the British North America Act, 1867. 3. Note 3, Section 2. Note 3. Section 2 repealed by the Statute Law Revision Act of 1893, 56-57, Queen Victoria, C14, United Kingdom. Read as follows. Note 3, Subsection 2. The provisions of this Act referring to Her Majesty the Queen extend also to the heirs and successors of Her Majesty, Kings and Queens of the United Kingdom of Great Britain and Northern Ireland. And Ireland. Not Northern Ireland. I guess the South was part of the UK at that time, or they had aspirations to own the whole thing. Interesting. Anyway, continuing. Note 4. The first day of July, 1867, was fixed by proclamation dated May 22, so that's May 22nd, 1867. Note 5. Partially repealed by the Statute Law Revision Act of 1893, 56-57, Queen Victoria, C14, United Kingdom. The section originally read as follows. Quote, Note 5, Subsection 4. The subsequent provisions of this Act shall, unless it is otherwise expressed or implied, commence and have effect on and after the Union, that is to say, on and after the days appointed by the Union taking effect in the Queen's proclamation, and in the same provisions, unless it is otherwise expressed or implied. The name Canada shall be taken to mean Canada as constituted under this Act. Note 6. Canada now consists of 10 provinces, in brackets, Ontario, Quebec, Nova Scotia, New Brunswick, Manitoba, British Columbia, Prince Edward Island, Alberta, Saskatchewan, and Newfoundland and Labrador. Newfoundland and Labrador is one province, just for those who aren't aware. And these 3 territories, Yukon, Northwest Territories, and Nunavut. The first territories added to the Union were Rupert's Land and the Northwestern Territory, in brackets, subsequently designated the Northwest Territories, which were admitted pursuant to Section 146 of the Constitution Act of 1867 and the Rupert's Land Act of 1868. 31-32 Queen Victoria C-105 United Kingdom by the Rupert's Land Act and Northwestern Territory Order of June 23, 1870, effective July 15, 1870. Prior to the admission of those territories, the Parliament of Canada enacted an act for the temporary government of Rupert's Land and the Northwestern Territory when united with Canada, in brackets 32-33 Victoria C3, and the Manitoba Act of 1870, in brackets 33 Victoria C3, which provided for the formation of the province of Manitoba. British Columbia was admitted into the Union pursuant to Section 146 of the Constitution Act of 1867 by the British Columbia Terms of Union, being Order in Council of May 16, 1871, effective July 20th of 1871. Prince Edward Island was admitted pursuant to Section 146 of the Constitution Act of 1867 by the Prince Edward Island Terms of Union, being Order in Council of June 26, 1873, effective July 1st, 1873. On June 29, 1871, the United Kingdom Parliament enacted the Constitution Act of 1871, in brackets 34-35, Queen Victoria C28, authorizing the creation of additional provinces out of territories not included in any existing province. Pursuant to this statute, the Parliament of Canada enacted the Alberta Act in July 20th, July 20th, 1905, 4-5 King Edward VII, C3, and the Saskatchewan Act, July 20th, 1905, 4-5 King Edward VII, C42, providing for the creation of the provinces of Alberta and Saskatchewan, respectively. Both of these acts came into force on September 1st, 1905. Meanwhile, all remaining British possessions and territories in North America and the islands adjacent thereto, except for the colony of Newfoundland, it's Newfoundland or Newfoundland, Newfoundland, depending on your pronunciation, and its dependencies, were admitted into the Canadian Confederation by the Adjacent Territories Order dated July 31st, 1880. Excuse me. The Parliament of Canada added portions of the Northwest Territories to the adjoining provinces in 1912 by the Ontario Boundaries Extension Act, SC 1912, to King George V, C40. The Quebec Boundaries Extension Act of 1912 to George V, C45. And the Manitoba Boundaries Extension Act of 1912, King George V, C32, and further additions were made to Manitoba by the Manitoba Boundaries Extension Act of 1930, 20-21, King George V, C28. The Yukon Territory was created out of a portion of the Northwest Territories in 1898 by the Yukon Territory Act 61, Queen Victoria C6. Newfoundland was added on March 31st, 1949 by the Newfoundland Act 12-13, King George VI, C22, United Kingdom, which ratified the terms of union of Newfoundland with Canada. Interesting then, so Newfoundland was independent of Canada during World War II and for 4 years after. I remember vaguely reading that years ago, but interesting to note, looking back on it. Anyway, continuing. Nunavut was created out of the Northwest Territories in 1999 by the Nunavut Act, SC 1993, C28. Note 7. See footnote 65 to section 129 below. Note 8. Repealed and reenacted by the Parliament of Canada Act 1875, 38-39, Queen Victoria C38, United Kingdom. The original section read as follows. Note 8, subsection 18, quote, "The privileges, immunities, and powers to be held, enjoyed, and exercised by the Senate and by the House of Commons and by the members thereof, respectively, shall be such as are from time to time defined by Act of Parliament of Canada, and so that the same shall never exceed those at the passing of this Act held, enjoyed, and exercised by the Commons House of Parliament of the United Kingdom of Great Britain and Ireland, and by the members thereof." Note 9. Spent. The first session of the first Parliament began on November 6, 1867. Note 10. Section 20. Repealed by the Constitution Act of 1982. It read as follows. Note 10, subsection 20. There shall be a session of the Parliament of Canada once a year once at least in every year, so that 12 months shall not intervene between the last sitting of the Parliament in one session and its first sitting in the next session. Section 20 has been replaced by Section 5 of the Constitution Act of 1982, which provides that there shall be a sitting of Parliament at least once every 12 months. Note 11. As amended by the Constitution Act of 1915, 5-6, King George V, C-45, United Kingdom, and modified by the Newfoundland Act, 12-13, King George VI, C-22, United Kingdom, the Constitution Act No. 2 of 1975, SC 1974-75-76, C-53, and the Constitution Act of 1999, in brackets Nunavut, SC 1998, C15 Part 2. The original section read as follows, quote, Note 11, subsection 21, the Senate shall, subject to the provisions of this Act, consist of 72 members who shall be styled senators. The Manitoba Act of 1870 added 2 senators for Manitoba. The British Columbia Terms of Union added 3. Upon admission of Prince Edward Island, 4 more were provided by Section 147 of the Constitution Act of 1867. The Alberta Act and the Saskatchewan Act each added 4. The Senate was reconstituted at 96 by the Constitution Act of 1915. 6 more senators were added upon union with Newfoundland, and 1 senator each was added for Yukon and the Northwest Territories by the Constitution Act No. 2 of 1975. 1 senator was added for Nunavut by the Constitution Act of 1999, in brackets Nunavut. Note 12. As amended by the Constitution Act of 1915, 5-6, King George V, C-45, United Kingdom, the Newfoundland Act, 12-13, King George VI, C-25, UK, the Constitution Act No. 2 of 1975, SC 1974-75-76, C-53, and the Constitution Act 1999, in brackets Nunavut, SC 1998, C-15, Part 2, the original section read as follows, quote, Note 2, subsection 22. In relation to the Constitution of the Senate, Canada shall be deemed to consist of 3 divisions. 1. Ontario. 2. Quebec. 3. The maritime provinces of Nova Scotia and New Brunswick. Which 3 divisions shall, subject to the provisions of this Act, be equally represented in the Senate as follows. Ontario by 24 senators, Quebec by 24 senators, and the Maritime Provinces by 24 senators, 12 thereof representing Nova Scotia and 12 thereof representing New Brunswick. In the case of Quebec, each of the 24 senators representing that province shall be appointed for one of the 24 electoral divisions of Lower Canada specified in Schedule A to Chapter 1 of the Consolidated Statutes of Canada. For those not aware, Lower Canada is what modern-day Quebec is, and Upper Canada was Ontario. The reason being basically just the lay of the land. Ontario is higher and the rivers flow downhill towards the ocean. Therefore, Upper Canada was Ontario and Lower Canada was Quebec. Quebec was formerly considered to be New France before it was conquered by the British, and for a while they changed the name, I would assume, to try and improve the integration of the Quebecois, but that didn't really fly. Anyway, continuing. The reference in Section 22 to the Consolidated Statutes of Canada is a reference to the Consolidated Statutes of 1859. Note 13, Section 44 of the Constitution Act 1999, in brackets Nunavut, SC 1998, C15 Part 2, provided that for the purposes of that part, which added 1 senator for Nunavut, The word province in Section 23 of the Constitution Act of 1867 has the same meaning as is assigned to the word province by Section 35 of the Interpretation Act, RSC 1985, CI 21, as amended, which provides that the term province means, quote, a province of Canada and includes Yukon, the Northwest Territories, and Nunavut, end quote. But the Yukon Territory isn't a province, it's a territory, and those are legally distinct. At least in the current modern day, I can see why those amendments would have been made, but that's still rather confusing unless there's something to follow it up later in this notation sheet, which there may well be. But in the presently constituted Constitution, the Yukon Territory, the Northwest Territories, and Nunavut are considered three separate quote-unquote territories. They are not provinces. They have different rights under the existing Constitution. Anyway, Section 2 of the Constitution Act number 2 of 1975, SC 1974, 75, 76, C53, provided that for the purposes of that act, which added one senator each for the Yukon Territory and the Northwest Territories, the term province in Section 23 of the Constitution Act of 1867 has the same meaning as is assigned the term province by Section 28 of the Interpretation Act, RSC 1970, CI 23, which provides the term province means a province of Canada and includes the Yukon Territory and the Northwest Territories. Note 14. Repealed by the Statute Law Revision Act, 1893, 56-57, Queen Victoria C-14, United Kingdom, the section reads as follows, quote, Note 14, subsection 25, such persons shall be the first summoned to the Senate as the Queen by warrant under Her Majesty Royal Sign Manual thinks fit to approve, and their names shall be inserted in the Queen's Proclamation of Union. Note 15. As amended by the Constitution Act of 1915, 5-6, King George V, C-45, United Kingdom, the original section read as follows. Note 15, subsections 26, quote, if at any time, on the recommendation of the Governor-General, the Queen thinks fit to direct that 3 or 6 members be added to the Senate, the Governor-General may be summoned may by summons to 3 or 6 qualified persons, as the case may be, representing equally the 3 divisions of Canada, add to the Senate accordingly. Note 16. As amended by the Constitution Act of 1915, 5-6, King George V, C-45, United Kingdom, the original section read as follows. Note 16, subsection 27, quote, in case of such addition being at any time made by the Governor-General, shall not summon any person to the Senate except on a further like direction by the Queen on the like recommendation, until each of the 3 divisions of Canada is represented by 24 senators and no more. Note 17. As amended by the Constitution Act of 1915, 5-6, King George V, C-45, United Kingdom, the Constitution Act number 2 of 1975, SC 1974, 75, 76, C-53, and the Constitution Act of 1999, in brackets Nunavut, SC 1998, C-15, Part 2, the original section read as follows. Note 17, subsection 28, quote, the number of senators shall not at any time exceed 78. Note 18, as enacted by the Constitution Act of 1965, SC 1965 C4, which came into force on June 2nd, 1965, the original section read as follows, quote, Note 18, subsection 29, a senator shall, subject to the provisions of this act, hold his place in the Senate for life. Yes, for those not aware, our senators are appointed by the existing prime minister when an existing senator dies, and then they are in place basically for life, although I think there might have been an amendment capping their maximum term of office at a certain age limit. However, they are basically there for life and more or less immovable. So it's not exactly democratic, but it's the system we have. Note 19. Provision for exercising the functions of Speaker during his or her absence is made by Part 2 of the Parliament of Canada Act, RSC 1985, CP-1, in brackets, formerly the Speaker of the Senate Act, RSC 1970, CS-14. Doubts as to the power of Parliament to enact the Speaker or the Senate Act were removed by the Canadian Speaker, in brackets, Appointment of Deputy Act of 1895, Second Session, 59 Victoria C3, United Kingdom, which was repealed by the Constitution Act of 1982. Note 20. The figures given here result from the application of Section 51 as enacted by the Constitution Act of 1985, in brackets, Representation, SC 1986, C8, Part 1, and amended by the Constitution Act of 1999, in brackets, Nunavut, SC 1995, C15, Part 2, and readjustments made pursuant to the Electoral Boundaries Readjustment Act, RSC 1985, CE3-3, the original section, in brackets, which was altered from time to time as the result of the addition of new provinces and change in population, reads as follows. Note 20, subsection 37, quote, the House of Commons shall, subject to the provisions of this Act, consist of 181 members, of whom 82 shall be elected for Ontario, 65 for Quebec, 19 for Nova Scotia, and 15 for New Brunswick. Note 21. Spent, the electoral districts are now established by proclamations issued from time to time under the Electoral Boundaries Readjustment Act, RSC 1985, CE3, as amended for particular districts by the Acts of Parliament. See the most recent table of public statutes and responsible ministers. Note 22. Spent. Elections are now provided for by the Canada Elections Act, SC 2000, C9, Qualifications and Disqualifications of Members by the Parliament of Canada Act, RSC 1985, CP-1. The right of citizens to vote and hold office is provided for in Section 3 of the Constitution Act of 1982. Note 23. Repeal by the Statute Law Revision Act 1893, 56-57, Queen Victoria, C14, United Kingdom. The section reads as follows. Note 23, subsection 42, quote, for the first election of members to serve in the House of Commons, the Governor-General shall cause writs to be issued by such person in such form and addressed to such returning officers as he thinks fit. The person issuing writs under the section shall have the like powers as are possessed at the Union by the officers charged with the issuing of writs for the election of members to serve in the respective House of Assembly or Legislative Assembly of the Province of Canada, Nova Scotia, or New Brunswick. And the returning officers to whom writs are directed under this section shall have the like powers as are possessed at the Union by the officers charged with the returning of writs for the election of members to serve in the same respective House of Assembly or Legislative Assembly. Note 24. Repealed by the Statute Law Revision Act of 1893, 56-57, Queen Victoria, C14, United Kingdom. The section reads as follows. 43. In case of a vacancy in the representation in the House of Commons of any electoral district happens before the meeting of the Parliament, or after the meeting of the Parliament, before provision is made by the Parliament in this behalf, the provisions of the last foregoing section of this Act shall extend and apply to the to the issuing and returning of a writ in respect of such vacant district. Note 25. Provision for exercising the functions of Speaker during his or her absence is now made by Part 3 of the Parliament of Canada Act, RSC 1985, CP-1. Note 26. The term of the 12th Parliament was extended by the British North America Act of 1916, 6-7, King George V, C19, United Kingdom, which Act was repealed by the Statute Law Revision Act of 1927, 17-18, King George V, C-42, United Kingdom. See also the Constitution Act of 1982, subsection 4.1, which provides that no House of Commons shall continue for longer than 5 years from the date fixed for the return of the writs at a general election of its members, and subsection 4.2, which provides for the continuation of the House of Commons in special circumstances. Note 27. As enacted by the Fair Representation Act, SC 2011, C26 S2, which came into force on royal assent on December 16th of 2011, the section as originally enacted reads as follows. Note 27, subsection 51, quote, on the completion of the census in the year 1871, and of each subsequent decennial census, the representation of the 4 provinces shall be readjusted, it should say readjusted, by such authority, in such manner, and from such time as the Parliament of Canada from time to time provides, subject and according to the following rules. Note 27, subsection 51, part 1. Quebec shall have the fixed number of 65 members. Note 27, subsection 51, part 2. There shall be assigned to each of the other provinces such a number of members as will bear the same proportion to the number of its population, in brackets ascertained at such and such a census, as the number 65 bears to the number of the population of Quebec, in brackets so ascertained. Note 27, subsection 51, part 3. In the computation of the number of members for a province, a fractional part not exceeding 1/2 of the whole number requisite for entitling the province to a member shall be disregarded. Pardon me. But a fractional part exceeding 1/2 of that number shall be equivalent to the whole number. In other words, they're rounding the number of representatives. Note 27, subsection 51, part 4. On any such readjustment, the number of members for a province shall not be reduced unless the proportion which the number of the population of the province bore to the number of the aggregate population of Canada at the then last preceding readjustment of the number of members for the province is ascertained at the then latest census to be diminished by 1/20th part or upwards. In other words, if you have a massive reduction in population in the province, the number of political representatives won't necessarily go down right away unless it's very, very drastic. Okay, note 27, subsection 51, part 5. Such readjustment shall not take effect until the termination of the then existing Parliament. Honestly, I can only think of like a few contexts where that might happen, like if there was a massive nuclear war or a famine or a plague or just like a general massive state of war like World War I or World War II where you have a draft and you're scraping the barrel. But that strikes me as unlikely, but I suppose the Constitution Act has to take account for the unlikely worst case scenario. Anyway, continuing. The section was amended by the Statute Law Revision Act of 1893, 56-57, Queen Victoria, C-14, United Kingdom, by repealing the words after, quote, of the census, end quote, to, quote, 71 and, end quote, and the words, quote unquote, subsequent. By the British North America Act, 1943, 6-7, King George VI, C-30, United Kingdom, which act was repealed by the Constitution Act of 1982. Redistribution of seats following the 1941 census was postponed until the first session of Parliament after the war. The section was reenacted by the British North America Act of 1946, 9-10, King George VI, C-63, United Kingdom, which act was also repealed by the Constitution Act of 1982 to read as follows. So this would be, I want to say, yes, this would be Note 27, Subsection 5, Subsection 51, Part 1. That is oddly numbered. In any case, quote, "The number of members of the House of Commons shall be 255, and the representation of the provinces therein shall forthwith upon the coming into force of this section, and thereafter on the completion of each decennial census, be readjusted by such authority in such manner and from such time as the Parliament of Canada from time to time provides, subject and according to the following rules. Rule 1. Subject as hereinafter provided, there shall be assigned to each of the provinces a number of members computed by dividing the total population of the provinces by 254 and dividing the population of each province by the quotient so obtained, disregarding, except as hereinafter in this section provided, the remainder, if any, after the said process of division." Let's see here. Rule 2. If the total number of members assigned to all the provinces pursuant to Rule 1 is less than 254, additional members shall be assigned to the provinces, in brackets, 1 to a province, having remainders in the computation under Rule 1, commencing with the province having the largest remainder and continuing with the other provinces in the order of the magnitude of their respective remainders until the total number of members assigned is 254. Rule 3. Notwithstanding anything in this section, if upon completion of a computation under Rules 1 and 2, the number of members to be assigned to a province is less than the number of senators representing the said province, Rules 1 and 2 shall cease to apply in respect of the said province, and there shall be assigned to the said province a number of members equal to the said number of senators. Rule 4. In the event that Rules 1 and 2 cease to apply in respect of a given province, then, for the purposes of computing the number of members to be assigned to the provinces, in respect of which Rules 1 and 2 continue to apply, the total population of the provinces shall be reduced by the number of the population of the province in respect of which Rules 1 and 2 have ceased to apply, and the number 254 shall be reduced by the number of members assigned to such province pursuant to Rule 3. Rule 5. Such readjustment shall not take effect until the termination of the then existing Parliament. And they have a thing here listing 2, but I don't know if that's going to be a new rule or a new subsection. I do believe that is 51 subsection 2, so that would be, in this case, Note 27 subsection the second set of subsection 51, and it's going to be -2. Of course, again, that partly because these are the notations at the back, the order of operations, so to speak, is somewhat sort of inaccurate and confusing to an extent as far as how to render it verbally. When you're actually looking at it on a page, it's fairly easy to follow. In any case, the Yukon Territory, as constituted by Chapter 41 of the Statutes of Canada 1901, together with any part of Canada not comprised within a province, which may from time to time be included therein by the Parliament of Canada for the purposes of representation in Parliament, shall be entitled to 1 member. The section was reenacted as follows by the British North America Act of 1952, SC 1952 C15, in brackets, which act was also repealed by the Constitution Act of 1982. 51-1. Subject as hereafter provided, the number of members of the House of Commons shall be 263, and the representatives of the provinces therein shall forthwith upon the coming into force of this section, and thereafter on the completion of each decennial census, be readjusted by such authority in such manner and from such time as the Parliament of Canada from time to time provides, subject and according to the following rules. Rule 1, there shall be assigned to each of the provinces a number of members, computed by dividing the total population of the provinces by 261, and by providing the population of each province by the quotient so obtained, disregarding except as hereinafter in this section provided, the remainder, if any, after the said process of division. Rule 2, if the total number of members assigned to all provinces pursuant to Rule 1 is less than 261, additional members shall be assigned to the provinces, in brackets 1 to a province, having remainders in the computation under Rule 1, commencing with the province having the largest remainder and continuing with the other provinces in the order of magnitude of their respective remainders until the total number of members assigned is 261. Rule 3, notwithstanding any of this section, if upon completion of a computation under Rules 1 and 2, the number of members to be assigned to a province is less than the number of senators representing the said province, Rules 1 and 2 shall cease to apply in respect of the said province, and there shall be assigned to the said province a number of members equal to the said number of senators. Rule 4, in the event that Rules 1 and 2 cease to apply in respect of a province, then, for the purposes of computing the number of members to be assigned to the provinces in respect of which Rules 1 and 2 continue to apply, the total population of the provinces shall be reduced by the number of the population of the province in respect of which Rules 1 and 2 have ceased to apply, and the number 261 shall be reduced by the number of members assigned to such provinces pursuant to Rule 3. Rule 5. On any such readjustment, the number of members for any province shall not be reduced by more than 15% below the representation to which such province was entitled under the Rules 1 to 4 of this subsection at the last proceeding readjustment of the representation of that province, and there shall be no reduction in the representation of any province, as a result of which that province would have a similar number of members than any other province that, according to the results of the then last decennial census, did not have a larger population, but for the purposes of any subsequent readjustments of representation under this section, any increase in the number of members of the House of Commons resulting from the application of this rule shall not be included in the divisor mentioned in Rules 1 to 4 of this subsection. 6. Such readjustments shall not take effect until the termination of the then existing Parliament. 2. The Yukon Territory, as constituted by Chapter 41 of the Statutes of Canada of 1901, shall be entitled to 1 member, and such other part of Canada not comprised within a province as may from time to time be defined by the Parliament of Canada shall be entitled to 1 member, regardless of population. Subsection 51, Part 1, was reenacted by the Constitution Act of 1974, SC 1974, 75, 76, C13, to read as follows. 51.1. The number of members of the House of Commons and the representation of the provinces therein shall, upon the coming into force of the subsection and thereafter on the completion of each decennial census, be readjusted by such authority in such manner and from such time as the Parliament of Canada from time to time provides, subject and according to the following rules. Rule 1. There shall be assigned to Quebec 75 members in the readjustment following the completion of the decennial census taken in the year 1971, and thereafter 4 additional members in each subsequent readjustment. Rule 2, subject to the Rules 5.2 and 5.3, there shall be assigned to a large province a number of members equal to the number obtained by dividing the population of the large province by the electoral quotient of Quebec. Rule 3, subject to Rule 5.2 and 5.3, there shall be assigned to a small province a number of members equal to the number obtained by dividing 3A, the sum of the populations determined according to the results of the penultimate decennial census of the provinces in brackets other than Quebec, having populations of less than 1.5 million, determined according to the results of that census by the sum of the number of members assigned to those provinces in the readjustment following the completion of the census, and 3B, the population of the small province by the quotient obtained under paragraph A. Again, note that they specifically name Quebec and give them special privileges by having, in theory, more representatives and representation in Parliament than they actually ordinarily would if they were treated on the same playing field as everyone else. Continuing. Rule 4. Subject to Rules 5.1a, 2, and 3, there shall be assigned to an intermediate province a number of members equal to the number obtained for A by dividing the sum of the populations of the provinces in brackets other than Quebec, having populations of less than 1.5 million, by the sum of the number of members assigned to those provinces under any of Rules 3, 5.1b, 2, and 3. 4b, by dividing the population of the intermediate provinces by the quotient obtained under paragraph A, and 4c, by adding to the number of members assigned to the intermediate provinces in the readjustment following the completion of the penultimate decennial census 1/2 of the difference resulting from the subtraction of that number from the quotient obtained under paragraph B. Rule 5, Part 1. On any readjustment, 5.1a, if no province other than Quebec has a population of less than 1.5 million, Rule 4 shall not be applied, and subject to Rules 5, 2, and 3, there shall be assigned to an intermediate province a number of members equal to the number obtained by dividing 1ai. The sum of the populations determined according to the results of the penultimate decennial census of the provinces other than Quebec, having populations of not less than 1.5 million and not more than 2.5 million, determined according to the results of that census by the sum of the number of members assigned to those provinces in the readjustment following the completion of that census, and 5.1a2, the population of the intermediate province by the quotient obtained under subparagraph 1. 5.1b. If a province other than Quebec having a population of 5.1b1 less than 1.5 million, or 5.1b2 not less than 1.5 million and not more than 2.5 million, does not have a population greater than its population determined according to the results of the penultimate decennial census, it shall, subject to Rule 5, 2, and 3, be assigned the number of members assigned to it in the readjustment following the completion of that census. Rule 5, Part 2. On any readjustment, Rule 5, Part 2a, if under any rules 2 to 5.1, the number of members to be assigned to a province in this paragraph referred to as the first province is smaller than the number of members to be assigned to any other province not having a population greater than that of the first province, those rules shall not be applied to the first province and shall instead be assigned a number of members equal to the largest number of members to be assigned to any other province not having a population greater than that of the first province. 5.2b, if under any rules 2 to 5.1a, the number of members to be assigned to a province is smaller than the number of members assigned to it in the readjustment following the completion of the penultimate decennial census, those rules shall not be applied to it, and it shall be assigned the latter number of members. 5.2c, if both paragraphs A and B apply to a province, it shall be assigned a number of members equal to the greater of the numbers produced under those paragraphs. 5.3. on any readjustment 5.3a if the electoral quotient of a province, in brackets, in this paragraph referred to as the first province, closing bracket, obtained by dividing its population by the number of members to be assigned to it under any of Rules 2 to 5.2, is greater than the electoral quotient of Quebec, those rules shall not be applied to the first province, and it shall be assigned to a number of members equal to the number obtained by dividing its population by the electoral quotient of Quebec. 5.3b. If, as a result of the application of Rule 6.2a, the number of members assigned to a province under paragraph A equals the number of members to be assigned to it under any of Rules 2 through 5.2, it shall be assigned that number of members, and paragraph A shall cease to apply to that province. Rule 6. In these rules, electoral quotient means, in respect of a province, the quotient obtained by dividing its population, determined according to the results of the then most recent decennial census, by the number of members to be assigned to it under any of Rules 1 to 5.3 in the readjustment following the completion of that census. Intermediate province means a province other than Quebec having a population greater than its population determined according to the results of the penultimate decennial census, but not more than 2.5 million and not less than 1.5 million. Large province meaning a province other than Quebec having a population greater than 2.5 million. Penultimate decennial census means the decennial census that preceded the then most recent decennial census. Population means, except where otherwise specified, the population determined according to the results of the then most recent decennial census. Small province means a province other than Quebec having a population greater than its population determined according to the results of the penultimate decennial census, and less than 1.5 million. Item 2. For the purposes of these rules, 2a, if any fraction less than 1 remains upon completion of the final calculation that produces the number of members to be assigned to a province, that number of members shall apply the number so produced, disregarding the fraction to B. If more than one readjustment follows the completion of decennial census, the most recent of those readjustments shall, upon taking effect, be deemed to be the only readjustment following the completion of that census. 2C. A readjustment shall not take effect until the termination of the then existing Parliament. Subsection 51(1) was reenacted by the Constitution Act of 1985, in brackets, Representation, SC 1998C Part 1, as follows. 51(1). The number of members of the House of Commons and the representation of the provinces therein shall, on the coming into force of this subsection and thereafter, on the completion of each decennial census, be readjusted by such authority, in such manner, and from such time as the Parliament of Canada from time to time provides, subject and according to the following rules. Rules. 1. There shall be assigned to each province a number of members equal to the number obtained by dividing the total population of the provinces by 279 and by dividing the population of each province by the quotient so obtained, counting any remainder in excess of 0.5 as one after the said process of division. Rule 2. If the total number of members that would be assigned to a province by the application of Rule 1 is less than the total number assigned to that province on the date of coming into force of this subsection, there shall be added to the number of members so assigned such number of members as will result in the province having the same number of members as were assigned on that date. Note 28. as enacted by the Constitution Act of 1999, in brackets Nunavut, SC 1998 C15 Part 2, note that the description of the territory of Yukon is now set out in Schedule 1 to the Yukon Act SC 2002 C7, which replaced RSC 1985 CY2 subsection 51(2), was previously amended by the Constitution Act No. 1, 1975, SC 1974 75 76, C28, and reads as follows. 2. The Yukon Act as bounded and described in the Schedule to Chapter Y2 of the Revised Statutes of Canada 1970 shall be entitled to one member, and the Northwest Territories as bounded and described in Section 2 of Chapter N2 of the Revised Statutes of Canada 1970 shall be entitled to 2 members. Note 29. As enacted by the Constitution Act 1915 56, GO v. C45 United Kingdom, the King George V C45 United Kingdom. Terribly sorry about that. Note 30. Provided by the Salaries Act, RSC 1985 CS3. Note 31. Provided for in Ontario by the Executive Council Act, RSO 1990, CE25, and in Quebec by the Executive Power Act, RSQ CE18. Note 32, a similar provision was included in each of the instruments admitting British Columbia, Prince Edward Island, and Newfoundland. The executive authorities for Manitoba, Alberta, and Saskatchewan were established by the statutes creating those provinces. See footnote 6 to section 5 above. Note 33, see footnote 65 to section 129 below. Note 34, spent, now covered by the Representation Act of 2005, SO 2005, C35, Schedule 1. Note 35, an act respecting the Legislative Council of Quebec, SQ 1968, C9, provided that the legislature for Quebec shall consist of the Lieutenant Governor and the National Assembly of Quebec, and repealed the provisions of the Legislature Act, RSQ 1964, C6, relating to the Legislative Council of Quebec. Now covered by the National Assembly Act, RSQ CA 23.1, Section 72 through 79, following are therefore completely spent. Note 36, an act respecting the electoral districts, SQ 1970 C7, provides that this section no longer has effect. Note 37, repealed by the Statute Law Revision Act of 1893, 56-57, Queen Victoria, C14, United Kingdom. This section read as follows. Note 37, subsection 81. Quote, the legislatures of Ontario and Quebec respectively shall be called together not later than 6 months after the Union. End quote. Note 38, probably spent. The subject matter of this section is now covered in Ontario by the Legislative Assembly Act, RSO 1990, CL10, and in Quebec by the National Assembly Act, RSQ CA 23.1. I find it interesting how they say probably, which implies uncertainty in a portion of the Canadian Constitution. That's not common. Note 39, probably spent. The subject matter of this section is now covered in Ontario by the Elections Act, RSO 1990 CE6, and the Legislative Assembly Act, RSO 1990 CL10, and in Quebec by the Elections Act, RSQ CE 3.3, and the National Assembly Act, RSQ CA-23.1. Note 40. The maximum duration of the Legislative Assembly of Quebec has been changed to 5 years. See the National Assembly Act, RSQ CA 23.1. See also Section 4 of the Constitution Act of 1982, which provides a maximum duration for a Legislative Assembly of 5 years, but also provides continuation in special circumstances. Note 41. See also Section 5 of the Constitution Act of 1982, which provides that there shall be a sitting of each legislature at least once every 12 months. Note 42. Partially repealed by the Statute Law Revision Act of 1893, 56-57, Queen Victoria C-14, United Kingdom, which deleted the following concluding words of the original enactment, quote, "And the House of Assembly of New Brunswick, existing at the passing of this act, shall, unless sooner dissolved, continue for the period for which it was elected." Also interesting to note, sooner appears to be misspelt. It's got one extra O in it for some reason. A similar provision was included in each of the instruments admitting British Columbia, Prince Edward Island, and Newfoundland. The legislatures of Manitoba, Alberta, and Saskatchewan were established by the statutes creating those provinces. See footnote 6 to section 5 above. See also Section 3 to 5 of the Constitution Act of 1982, which prescribed democratic rights applicable to all provinces, and Sub-Item 2.2 of the Schedule to that Act, which sets out the repeal of Section 20 of the Manitoba Act of 1870. Section 20 of the Manitoba Act 1870 has been replaced by Section 5 of the Constitution Act of 1982, and Section 20 read as follows. 20. There shall be a session of the legislature once at least in every year, so that 12 months shall not intervene between the last sitting of the legislature in one session and its first sitting in the next session. Note 43. Repealed by the Statute Law Revision Act of 1893, 56-57, Queen Victoria C-14, United Kingdom. The section read as follows. 89. Each of the Lieutenant Governors of Ontario, Quebec, and Nova Scotia shall cause writs to be issued for the first election of the members of the Legislative Assembly thereof in such form and by such person as he thinks fit, and at such time and addressed to such returning officer as the Governor-General directs, and so that the first election of member of Assembly for any electoral district or any subdivision thereof shall be held at the same time and at the same places as the section for a member to serve in the House of Commons of Canada for that electoral district. Note 44. A new Class 1 was added by the British North America Act No. 2 Act of 1949. 13 King George VI, C-81, United Kingdom. That Act and Class 1 were repealed by the Constitution Act of 1982. The matters referred to in Class 1 are provided for in Subsection 4.2 and Part 5 of the Constitution Act of 1982. As enacted, Class 1 read as follows, quote, 1. The amendment from time to time of the Constitution of Canada, except as regards matters coming within the classes of subjects by this Act assigned exclusively to the legislatures of the provinces, or as regards rights or privileges for this or any other constitutional act granted or secured to the legislature or the government of a province, or to any class of persons with respect to schools, or as regards the use of English or the French language, or as regards the requirements that there shall be a session of the Parliament of Canada at least once each year, and no House of Commons shall continue for more than 5 years from the day of the return of the writs for choosing the House choosing the House. Provided, however, that the House of Commons may in time of real or apprehended war, invasion, or insurrection be continued by the Parliament of Canada if such continuation is not opposed by the votes of more than 1/3 of the members of such House. Note 45. The original Class 1 was renumbered by the British North America No. 2 Act of 1949, 13 King George VI, C-81, United Kingdom, as Class 1A. Note 46. Added by the Constitution Act of 1940, 3-4 King George VI, C-36, United Kingdom. Note 47. Legislative authority has been conferred on Parliament by other acts. Acts conferring legislative authority on Parliament. 1. The Constitution Act of 1871, 34-5, Queen Victoria, C-28, United Kingdom. 2. The Parliament of Canada may, from time to time, establish new provinces in any territories forming, for the time being, part of the Dominion of Canada, but not included in any existing province thereof, and may, at the time of such establishment, make provision for the constitution and administration of any such province, and for the passing of laws for the peace, order, and good government of such province, and for its representation in the said Parliament. 3. The Parliament of Canada may, from time to time, with the consent of the legislature of any province of the said Dominion, increase, diminish, or otherwise alter the limits of such province upon such terms and conditions as may be agreed to by the said legislature, and may, with the like consent, make provision respecting the effect and the operation of any such increase or diminution or alteration of territory in relation to any province affected thereby. 4. The Parliament of Canada may, from time to time, make provision for the administration, peace, order, and good government of any territory not for the time being included in any province. 5. The following acts passed by the said Parliament of Canada and entitled, respectively, an Act for the temporary government of Rupert's Land and the Northwestern Territory when united with Canada, and an Act to amend and continue the Act 32 and 33, Victoria, Chapter 3, and to establish and provide for the government of the province of Manitoba, shall be and be deemed to have been valid and effectual for all purposes whatsoever from the date at which they respectively received the assent in the Queen's name of the Governor-General of the said Dominion of Canada. 6. Except as provided by the third section of this Act, it shall not be competent for the Parliament of Canada to alter the provisions of the last mentioned Act of the said Parliament insofar as it relates to the province of Manitoba, or of any other Act hereafter establishing new provinces in the said Dominion, subject always to the right of the legislature of the province of Manitoba to alter from time to time the provisions of any law respecting the qualification of electors and members of the Legislative Assembly, and to make laws respecting elections in the said province. The Rupert's Land Act of 1868, 31-32, Queen Victoria C. 105, United Kingdom, repealed by the Statute Law Revision Act of 1893, 56-57, Queen Victoria C. 14, United Kingdom, had previously conferred similar authority in relation to Rupert's Land and the Northwestern Territory upon admission of those areas to Confederation. 2. The Constitution Act of 1886, 49-50, Victoria C. 35, United Kingdom. The Parliament of Canada may, from time to time, make provision for the representation in the Senate and House of Commons of Canada, or in either of them, of any territories which for the time being form part of the Dominion of Canada but are not included in any province thereof. 3. The Statute of Westminster, 1931, 22 George V, C4, United Kingdom. 3. It is hereby declared and enacted that the Parliament of a Dominion has full power to make laws having extraterritorial operation. 4. Under Section 44 of the Constitution Act of 1982, Parliament has exclusive authority to amend the Constitution of Canada in relation to the Executive Government of Canada or the Senate and House of Commons. Section 38, 41, 42, and 43 of that Act authorize the Senate and House of Commons to give their approval to certain other constitutional amendments by resolution. Item 48. Class 1 was repealed by the Constitution Act of 1982. As enacted, it read as follows. 1. The amendment from time to time, notwithstanding any in this Act, of the Constitution of the province, except as regards the office of Lieutenant Governor. Section 45 of the Constitution Act of 1982 now authorizes legislatures to make laws amending the Constitution of the province. Section 38, 41, 42, and 43 of that Act authorize legislative assemblies to give their approval by resolution to certain other amendments of the Constitution of Canada. Note 49. Added by Section 50 of the Constitution Act 1982. Note 50. Alternative provisions have been enacted for 4 provinces. An alternative was provided for Manitoba by Section 22 of the Manitoba Act of 1970, 33 Queen Victoria C3, in brackets confirmed by the Constitution Act of 1871, 34-35, Queen Victoria C28, United Kingdom, which selection reads as follows. 22. In and for the province, the said legislature may exclusively make laws in relation to education, subject and according to the following provisions. Provision 1. Nothing in any such law shall prejudicially affect any right or privilege with respect to denominational schools which any class of persons have by law or practice in the province at the Union. Provision 2. An appeal shall lie to the Governor-General in Council from any act or decision of the legislature of the province or of any provincial authority affecting any right of or privilege of the Protestant or Roman Catholic minority of the Queen's subjects in relation to education. Provision 3. In case any such provincial law, as from time to time seems to the Governor-General in Council requisite for the due execution of the provisions of this section, is not made, or in case any decision of the Governor-General in Council on any appeal under this section is not duly executed by the proper provincial authority in that behalf, then and in every such case, and as far only as the circumstances of each case require, the Parliament of Canada may make remedial laws for the due execution of the provisions of the section and of any decision of the Governor-General in Council under this section. An alternative was provided for Alberta by Section 17 of the Alberta Act of 1905, 4-5 King Edward VII, C3, which reads as follows. 17. Section 93 of the Constitution Act of 1867 shall apply to the said province with the substitution for paragraph 1 of the said section 93 of the following paragraph. 1. Nothing in any such law shall prejudicially affect any right or privilege with respect to separate schools which any class of persons have at the date of the passing of this Act under the terms of Chapters 29 and 30 of the Ordinances of the Northwest Territories passed in the year 1901, or with respect to religious instruction in any public or separate school as provided for in the said ordinances. 2. In the appropriation by the legislature or distribution by the government of the province of any monies for the support of schools organized and carried out in accordance with the said Chapter 29, or any act passed in amendment thereof, or in substitution therefor, there shall be no discrimination against schools of any class described in the said Chapter 29. 3. Where the expression by law is employed in, by law, is employed in paragraph 3 of the said section 93, it shall be held to mean the law as set out in the said chapters 29 and 30, and where the expression quote unquote at the Union is employed in the said paragraph 3, it shall be held to mean the date at which this act comes into force. An alternative was provided for Saskatchewan by Section 17 of the Saskatchewan Act of 1905, 4-5 King Edward VII, C42, which section reads as follows. 17. Section 93 of the Constitution Act of 1867 shall apply to the said province with the substitution for paragraph 1 of the said Section 93 of the following paragraph. 1. Nothing in any such law shall prejudicially affect any right or privilege with respect to separate schools which any class of persons have at the date of the passing of this Act under the terms of Chapter 29 and 30 of the Ordinances of the Northwest Territories, passed in the year 1901, or with respect to religious instruction, religious instruction in any public or separate schools as provided for in the said ordinances. 2. In the appropriation by the legislature or distribution by the government of the provinces of any moneys for the support of schools organized and carried out in accordance with the said Chapter 29, or any act passed in amendment thereof, or in substitution therefor, there shall be no discrimination against schools of any class described in the said Chapter 29. 3. Where the expression by law is employed in paragraph 3 of the said section 93, it shall be held to mean the law as set out in the said chapters 29 and 30, and where the expression at the Union is employed in said paragraph 3, it shall be held to mean the date at which this act comes into force. An alternative was provided for Newfoundland by terms 17 of the Terms of Union of Newfoundland with Canada, confirmed by the Newfoundland Act 12-13, King George VI, C-22, United Kingdom. Term 17 of the Terms of Union of Newfoundland with Canada, set out in the penultimate paragraph of this note, was amended by the Constitution Amendment of 1998, in brackets Newfoundland Act, CSI/98-25, and the Constitution Amendment of 2001, in brackets Newfoundland and Labrador, CSI/2001-117, and now reads as follows. 17. Part 1. In lieu of Section 93 of the Constitution Act of 1867, this term shall apply in respect of the province of Newfoundland and Labrador. 2. In and for the province of Newfoundland and Labrador, the legislature shall have exclusive authority to make laws in relation to education, but shall provide for courses in religion that are not specific to a religious denomination. 3. Religious observances shall be permitted in a school where requested by parents. Prior to the Constitution Amendment of 1998, in brackets Newfoundland Act, Term 17 of the Terms of Union of Newfoundland with Canada had been amended by the Constitutional Amendment of 1997, in brackets Newfoundland Act, CSI/97-55, to read as follows. 17. In lieu of Section 93 of the Constitution Act of 1867, the following shall apply in respect of the province of Newfoundland. In and for the province of Newfoundland, the legislature shall have exclusive authority to make laws in relation to education, but A. Except as provided in paragraphs B and C, schools established, maintained, and operated with public funds shall be denominational schools, and any class of persons having rights under this term as it read on January 1st of 1995 shall continue to have the rights to provide for religious education, activities, and observances for the children of that class in those schools, and the group of classes that formed one integrated school system by agreement in 1969 may exercise the same rights under this term as a single class of persons. Article B. Subject to provincial legislation that is uniformly applicable to all schools, specifying conditions for the establishment or continued operation of schools. Article B, subsection I. Any class of persons referred to in paragraph A shall have the right to have a publicly funded denominational school established, maintained, and operated, especially for that class, and, Article B, subsection II, the legislature may approve the establishment, maintenance, and operation of a publicly funded school, whether denominational or non-denominational. Article C. where a school is established, maintained, and operated pursuant to subparagraph B, Part I, the class of persons referred to in that subparagraph shall continue to have the rights to provide for religious educational activities and observances and to direct the teaching of aspects of curriculum affecting religious beliefs, student admission policy, and the assignment and dismissal of teachers in that school. Article D. All schools referred to in paragraphs A and B shall receive their share of public funds in accordance with scales determined on a non-discriminatory basis from time to time by the legislature, and E. If the classes of persons having rights under this term so desire, they shall have the right to elect in total not less than 2/3 of the members of a school board, and any class so desiring shall have the right to elect the portion of that total that is proportionate to the population of that class in the area under the board's jurisdiction. Prior to the Constitution Amendment of 1997, in brackets Newfoundland Act, Term 17 of the Terms of Union of Newfoundland with Canada had been amended by the Constitution Amendment of 1987, in brackets Newfoundland Act, CSI/88-11, to read as follows. Item 17, Part 1. In lieu of Section 93 of the Constitution Act of 1867, the following term shall apply in respect of the Province of Newfoundland, now the Province of Newfoundland and Labrador. In and for the Province of Newfoundland, the legislature shall have exclusive authority to make laws in relation to education, but the legislature will not have authority to make laws prejudicially affecting any rights or privilege with respect to denominational schools, common amalgamated schools, or denominational colleges, that any class or class of persons having by law in Newfoundland at the date of union and out of public funds of the Province of Newfoundland provided for education. Article 17, subsection 1A. All such schools shall receive their share of such funds in accordance with scales determined on a non-discriminatory basis from time to time by the legislature for all schools then being conducted under authority of the legislature, and Article 17, subsection 1b, all such colleges shall receive their share of any grant from time to time voted for any colleges then being conducted under authority of the legislature, such grants being distributed on a non-discriminatory basis. Article 17, subsection 2. For the purposes of paragraph 1 of this term, the Pentecostal Assemblies of Newfoundland have in Newfoundland all the same rights and privileges with respect to denominational schools and denominational colleges as any other class or classes of persons had by law in Newfoundland at the date of union, and the words, quote-unquote, all such schools in paragraph A of paragraph 1 of this term, and the words all such colleges in paragraph B of paragraph 1 of this term include respectively the schools and colleges of the Pentecostal Assemblies of Newfoundland. Term 17 of the Terms of Union of Newfoundland with Canada, in brackets, confirmed by the Newfoundland Act 12-13 King George VI, C-22 United Kingdom, which term provides an alternative for Newfoundland, originally read as follows. 17. In lieu of Section 93 of the Constitution Act of 1867, the following term shall apply in respect of the Province of Newfoundland. In and for the Province of Newfoundland, the legislature shall have exclusive authority to make laws in relation to education, but the legislature will not have authority to make laws prejudicially affecting any right or privilege with respect to the denominational schools, common amalgamated schools, or denominational colleges that any class or classes of persons have by law in Newfoundland at the date of union and out of public funds of the Province of Newfoundland provided for education. 17, Part A. All such schools shall receive their share of such funds in accordance with the scales determined on a non-discriminatory basis from time to time by the legislature for all schools then being conducted under authority of the legislature, and Part 17, Subpart B, All such colleges shall receive their share of any grant from time to time voted for, all colleges then being conducted under authority of the legislature, such grant being distributed on a non-discriminatory basis. See also sections 23, 29, and 59 of the Constitution Act of 1982. Section 23 provides for new minority language educational rights, and Section 59 permits a delay in respect of the coming into force in Quebec of any aspect of those rights. Section 29 provides that nothing in the Canadian Charter of Rights and Freedoms abrogates or derogates from any right or privilege guaranteed by or under the Constitution of Canada in respect of denominational, separate, or dissentient schools. Note 51. Added by the Constitution Amendment of 1997 in brackets Quebec. CSI/97-141. Note 52, amended by the Constitution Act of 1964, 12-13, Queen Elizabeth II, Long May She Reign, C-73, United Kingdom, as originally enacted by the British North America Act of 1951, 14-15, King George VI, C-32, United Kingdom, which was repealed by the Constitution Act of 1982, Section 94A, read as follows. 94A. It is hereby declared that the Parliament of Canada may from time to time make laws in relation to old age pensions in Canada, but no law made by the Parliament of Canada in relation to old age pensions shall affect the operation of any law, present or future, of a provincial legislature in relation to old age pensions. Note 53. Amended by the Constitution Act circa 1960, 9, Queen Elizabeth II, C2, United Kingdom, which came into force on March the 1st of 1961. The original section read as follows. Note 99. Article 99. The judges of the superior courts shall hold office during good behavior, but shall be removed by the Governor General on address of the Senate and House of Commons. Note 54. Now provided for in the Judges Act, RSC 1985, CJ-1. Note 55. See the Supreme Court Act, RSC 1985, CS-26, the Federal Courts Act, RSC 1985, CF-7, and the Tax Court of Canada Act, RSC 1985, CT-2. Note 56. Now covered by the Governor General's Act, RSC 1985, CG-9. Note 57. Manitoba, Alberta, and Saskatchewan were placed in the same position as the original provinces by the Constitution Act of 1930, 20-21, that would be paragraphs 20 through 21, King George V, C-26, United Kingdom. These matters were dealt with in respect of British Columbia by the British Columbia Terms of Union and also in part by the Constitution Act of 1930. The Newfoundland was also placed in the same position by the Newfoundland Act, 12-13, King George VI, C-22, United Kingdom. With respect to Prince Edward Island, see the schedule to the Prince Edward Island Terms of Union. Note 58. The obligations imposed by Section 114, 115, and 116 are similar obligations under the instruments creating or admitting other provinces are now to be found in the Provincial Subsidies Act, RSC 1985, CP-26. Note 59. Repealed by the Statute Law Revision Act of 1950, 14, King George VI, C6, United Kingdom. The section originally read as follows. Article 118. The following sums shall be paid yearly by Canada to the several provinces for the support of their governments and legislatures. Ontario, in Canadian dollars, $80,000. Quebec, in Canadian dollars, $70,000. Nova Scotia, in Canadian dollars, $60,000, and New Brunswick, in Canadian dollars, $50,000. Also below that, it says $260,000, although there doesn't appear to be a province earmarked for that funds, so it's probably at the discretion of whomever is in charge at that point in time. And an annual grant in aid of each province shall be made equal to 80 cents per head of the population as ascertained by the census of 1,861, and in the case of Nova Scotia and New Brunswick, by each subsequent decennial census until the population of each of these two provinces amounts to 400,000 souls, at which rate such grant shall thereafter remain. Such grants shall be in full settlement of all future demands on Canada, and shall be paid half yearly in advance to each province by the government of Canada. But the government of Canada shall deduct from such grants as against any province all sums chargeable as interest on the public debt of that province in excess of several amounts stipulated in this Act. The section was made obsolete by the Constitution Act of 1907, King Edward VII, C11 United Kingdom, which provided Article 1, Subsection 1, the following grants shall be made yearly by Canada to every province, which at the commencement of this Act is a province of the Dominion for its local purposes and the support of its government and legislature. Article 1, Subsection 1a, a fixed grant, where the population of the province is under 150,000 of $100,000, where the population of the province is 150,000 but does not exceed 200,000, an amount of $150,000, where the population of the province is 200,000 but does not exceed where the population of the province is 200,000 but does not exceed 400,000 of $180,000, where the population of the province is 400,000 souls but does not exceed 800,000 souls, an amount of $190,000. Where the population of the province is 800,000 but does not exceed 1,500,000, an amount of $220,000, where the population of the province exceeds 1,500,000 of $240,000, and B, subject to the special provisions of this Act to the as to the provinces of British Columbia and Prince Edward Island, a grant at the rate of 80 cents per head of the population of the province, up to the number of 2,500,000, and at the rate of 60 cents per head of so much of the population as exceeds that number. 2. An additional grant of $100,000 shall be made yearly by the province of British Columbia for a period of 10 years from the commencement of this Act. 3. The population of a province shall be ascertained from time to time in the case of the provinces of Manitoba, Saskatchewan, and Alberta, respectively, by the last quintennial census or statutory estimate of population made under the acts establishing these provinces or any other act of the Parliament of Canada making provisions for the purpose, and in the case of any other provinces by the last decennial census of the decennial census for the time being. 4. The grants payable under this Act shall be paid half yearly in advance to each province. 5. The grants payable under this Act shall be substituted for the grants or subsidies, in brackets, in this Act referred to as existing grants, closing bracket, payable for the like purposes at the commencement of this Act to the several provinces of the Dominion under the provisions of Section 118 of the Constitution Act of 1867, or in any order in council establishing a province, or of any act of the Parliament of Canada containing directions for the payment of any such grant or subsidy, and those provisions shall cease to have effect. 6. The Government of Canada shall have the same power of deducting sums charged against a province on account of the interest on public debt in the case of the grant payable under this Act to the province as they have in the case of the existing grant. 7. Nothing in this Act shall affect the obligation of the Government of Canada to pay to any province any grant which is payable to that province other than the existing grant for which the grant under this Act is substituted. 8. In the case of the provinces of British Columbia and Prince Edward Island, the amount paid on account of the grant payable per head of the population to the provinces under this Act shall not in any time be less than the amount of the corresponding grant payable at the commencement of this Act, and if it is found on any decennial census that the population of the province has decreased since the last decennial census, the amount paid on account of the grant shall not be decreased below the amount then payable, notwithstanding the decrease of the population. See Provincial Subsidies Act, RSC 1985, CP 26, and the Federal Provincial Fiscal Arrangements Act, RSC 1985, CF-8. See also Part 3 of the Constitution Act of 1982, which sets out the commitments by Parliament and the provincial legislatures respecting equal opportunities, economic development, and the provision of essential public services, and the commitment by Parliament and the Government of Canada to the principle of making equalization payments. Note 60, spent. Note 61, spent. Now covered by the Customs Act, RSC 1985, C1, in brackets, second sup, so I assume that would be support, although I don't know for sure. The Customs Tariff, SC 1997, C36, the Excise Act, RSC 1985, CE-14, the Excise Act of 2001, SC 2002, C22, and the Excise Tax Act, RSC 1985, CE-15. Note 62, spent. Note 63, these dues were repealed in 1873 by 36 Queen Victoria C16 NB, would be New Brunswick, I assume, although I could be wrong. Also see an act respecting the export duties imposed on lumber, etc., in brackets 1873, 36 Queen Victoria C41, in brackets Canada, and Section 2 of the Provincial Subsidies Act, RSC 1985, CP 26. Note 64, repealed by the Statute Law Revision Act of 1893, 56-57, Queen Victoria C14, United Kingdom. The section read as follows. Article 127. If any person being at the passing of this Act a member of the Legislative Council of Canada, Nova Scotia, or New Brunswick, to whom a place in the Senate is offered, does not within 30 days thereafter, by writing under his hand addressed to the Governor-General of the Province of Canada, or to the Lieutenant Governor of Nova Scotia or New Brunswick, as the case may be, accept the same, he shall be deemed to have declined the same. And any persons who, being at the passing of this Act, a member of the Legislative Council of Nova Scotia or New Brunswick, accepts a place in the Senate, shall thereby vacate his seat in such legislative council. Note 65. The restriction against altering or repealing laws enacted by or existing under statutes of the United Kingdom was removed by the Statute of Westminster, circa 1931, 22 King George V, C4 United Kingdom, except in respect of certain constitutional documents. Comprehensive procedures for amending enactments forming part of the Constitution of Canada were provided by Part 5 of the Constitution Act of 1982. Note 66, spent. Note 67. A similar provision was enacted for Manitoba by Section 23 of the Manitoba Act, circa 1870, 33 Queen Victoria C3 in brackets confirmed by the Constitution Act of 1871, 34-35 Queen Victoria C28 United Kingdom. Section 23 reads as follows. Note 23. Either the English or the French language may be used by any person in the debates on the House of Commons, in the debates of the House of Commons or of the legislature. And both these languages shall be used in the respective records and journals of those houses, and either of those languages may be used by any person or in any pleading or process in or issuing from any court of Canada established under the British North America Act of 1867, or in or from all of or any of the courts of the province. The acts of the legislature shall be printed and published in both of these languages. Sections 17 to 19 of the Constitution Act of 1982 restate the language rights set out in Section 133 in respect of Parliament and the courts established under the Constitution Act of 1867, and also guarantee those rights in respect of the legislature of New Brunswick and the courts of that province. Sections 16, 20, 21, and 23 of the Constitution Act of 1982 recognize additional language rights in respect of the English and French languages. Section 22 preserves language rights and privileges of languages other than English and French. Note 68. Spent. Now covered in Ontario by the Executive Council Act, RSO 1990, CE 25, and in Quebec by the Executive Power Act, RSQ CE-18. 69. Probably spent. 70. Probably spent. 71. Probably spent. Again, I find it very odd that they would leave that in doubt. Note 72. Spent. Penitentiaries are now provided for by the Corrections and Conditional Release Act, SC 1992, C20. Note 73. Spent. See pages XI and XII, so that would be, if I'm not mistaken here, 11 and 12 of the public accounts of 1902 to 1903. Note 74. Probably spent. 2 orders were made under this section on January 24th, 1868. I have no idea what that means, or what that is in reference to. I would have to look back to the source for the note, back on whatever article of the Constitution as it is currently rendered they are referring to. Note 75. Repealed by the Statute Law Revision Act 1893, 56-57, Queen Victoria C14, United Kingdom, the section reads as follows. Article 145. Inasmuch as the provinces of Canada, Nova Scotia, and New Brunswick have joined in a declaration that the construction of the intercolonial railway is essential to the consolidation of the Union of British North America and to the assent thereto of Nova Scotia and New Brunswick, and have consequently agreed that provision should be made for its immediate construction by the Government of Canada. Therefore, In order to give effect to that agreement, it shall be the duty of the Government and Parliament of Canada to provide for the commencement within 6 months after the Union of a railway connecting the River St. Lawrence with the city of Halifax in Nova Scotia, and for the construction thereof without intermission, and the completion thereof with all practicable speed. Note 76. All territories mentioned in Section 146 are now part of Canada. See footnote 6 to Section 5 above. Note 77. Spent. See footnotes 11, 12, 15, 16, and 17 to Sections 21, 22, 26, 27, and 28 above. Note 78. Spent. See Representation Act, RSO 1990, CR 26, Note 79, as enacted by Section 51 of the Constitution Act of 1982, Note 80, enacted as Schedule B to the Canada Act of 1982, 1982, C11 United Kingdom, which came into force on April 17th of 1982. The Canada Act of 1982, other than Schedules A and B thereto, reads as follows. An act to give effect to the request by the Senate and House of Commons of Canada, whereas Canada has requested and consented to the enactment of an act of the Parliament of the United Kingdom to give effect to the provisions herein after set forth, and the Senate and the House of Commons of Canada in Parliament assembled have submitted an address to Her Majesty the Queen, requesting that Her Majesty may graciously be pleased to cause a bill to be laid before the Parliament of the United Kingdom for that purpose. Be it therefore enacted by the Queen's most excellent Majesty, by and with the advice and consent of the Lord, spiritual and temporal and commons, in this present Parliament assembled, and by the authority of the same, as follows. 1. The Constitution Act of 1982, set out in Schedule B to this Act, is hereby enacted for, and shall have the force of law in Canada, and shall come into force as provided in that Act. 2. No act of the Parliament of the United Kingdom passed after the Constitution Act of 1982 comes into force shall extend to Canada as part of its law. 3. So far as it is not contained in Schedule B, the French version of this Act is set out in Schedule A to this Act and has the same authority in Canada as the English version thereof. 4. This Act may be cited as the Canada Act of 1982. Note 81. See Section 50 and footnotes 40 and 42 to Section 85 and 88 of the Constitution Act of 1867. Note 82. Replaces part of Class 1 of Section 91 of the Constitution Act of 1867, which was repealed as set out in Sub-Item 1, Part 3 of the Schedule to the Constitution Act of 1982. Note 83. See footnotes 10, 41, and 42 to Section 20, 86, and 88 of the Constitution Act of 1867. Note 84. Subsection 32(2) provides that Section 15 shall not have effect until 3 years after Section 32 comes into full force. Section 32 came into force on April 17th of 1982, therefore Section 15 had effect on April 17th, 1985. Note 85. Section 16.1 was added by the Constitution Amendment of 1993, in brackets New Brunswick, CSI 93-54. Note 86. See Section 133 of the Constitution Act of 1867 and footnote 67. Note 87, ibid. Note 88, ibid. Note 89, ibid. Note 90, ibid. Note 91, ibid, which means all of those refer to Note 86. Note 92. See, for example, Section 133 of the Constitution Act of 1867 and the reference to the Manitoba Act of 1870 in the footnote 67 to that section. Note 93. Paragraph 23, Part 1A is not in force in respect of Quebec. See Section 59 below. Note 94. Paragraph 25, Part B, was repealed and reenacted by the Constitution Amendment Proclamation of 1983, CSI 84-102, Paragraph 25B, originally read as follows. B. Any rights or freedoms that may be acquired by the Aboriginal peoples of Canada by way of land claims settlement. Note 95. See Section 93 of the Constitution Act of 1867 and footnote 50. Note 96. Subsections 35.3 and 35.4 were added by the Constitution Amendment Proclamation of 1983, CSI/84-102. Note 97. Section 35.1 was added by the Constitution Amendment Proclamation of 1983, CSI/84-102. Note 98. See footnotes 58 and 59 to sections 114 and 118 of the Constitution Act of 1867. Note 99. Section 54 of the Constitution Act of 1982 provided for the repeal of Part 4, Section 37, 1 year after Part 7 came into force. Part 7 came into force on April 17, 1982, repealing Part 4 on April 17, 1983. Section 37 read as follows. Section 37, Part 1. A constitutional conference composed of the Prime Minister of Canada and the First Ministers of the provinces shall be convened by the Prime Minister of Canada within 1 year after this part comes into force. Note 37, Part 2. The conference convened under subsection 1 shall have included in its agenda an item respecting constitutional matters that directly affect the Aboriginal peoples of Canada, including the identification and definition of the rights of those peoples to be included in the Constitution of Canada, and the Prime Minister of Canada shall invite representatives of those peoples to participate in the discussions on that item. Section 37, subsection 3. The Prime Minister of Canada shall invite elected representatives of the governments of the Yukon Territory and the Northwest Territories to participate in the discussion on any item on the agenda of the conference convened under subsection 1 that, in the opinion of the Prime Minister, directly affects the Yukon Territory and the Northwest Territories. Note 100. Part 4.1, section 37.1 is in brackets, which was added by the Constitution Amendment Proclamation of 1983, in brackets CSI/84-102, was repealed on April 18th of 1987 by Section 54.1 of the Constitution Act of 1982. Section 37.1 read as follows. 37.1, Part 1. In addition to the conference convened in March of 1983, at least 2 constitutional conferences composed of the Prime Minister of Canada and the First Ministers of the provinces shall be convened by the Prime Minister of Canada, the first within 3 years after April 17, 1982, and the second within 5 years after that date. 2. Each conference convened under subsection 1 shall have included in its agenda constitutional matters that directly affect the Aboriginal peoples of Canada, and the Prime Minister of Canada shall invite representatives of those peoples to participate in the discussions of those matters. 3. The Prime Minister of Canada shall invite elected representatives of the governments of the Yukon Territory and the Northwest Territories to participate in the discussions on any item on the agenda of a conference convened under subsection 1 that, in the opinion of the Prime Minister, directly affects the Yukon Territory and the Northwest Territories. 4. Nothing in this section shall be construed so as to derogate from subsection 35, part 1. Note 101. Prior to the enactments of Part 5, certain provisions of the Constitution of Canada and the provincial constitutions could be amended pursuant to the Constitution Act of 1867. See footnotes 44 and 48 to Section 91, Class 1, and Section 92, Class 1 of that Act, respectively. Other amendments to the Constitution could only be made by enactment of the Parliament of the United Kingdom. Note 102. A First Minister's meeting was held June 20-21, so that's 20th and through 21st of 1996. It took 2 days, long meeting. Note 103. The text of this amendment is set out in the Constitution Act of 1867 as Section 92A. Note 104. The text of this amendment is set out in the Constitution Act of 1867 as the 6th Schedule. Note 105. Part 7 came into force on April 17th of 1982, CSI/82-97. Note 106. Section 54.1, which was added by the Constitution Amendment Proclamation of 1983, CSI/84-102, provided for the repeal of Part 4.1 and Section 54.1 on April 18th of 1987. Section 54.1 read as follows. 54.1, Part 4.1, and this section are repealed on April 18th of 1987. Note 107. The French Constitutional Drafting Committee was established in 1984 with a mandate to assist the Minister of Justice in that task. The committee's final report was tabled in Parliament in December of 1990. Note 108. The Act, with the exception of paragraph 23, part 1, subsection A, in respect of Quebec, came into force on April 17th, 1982, by proclamation issued by the Queen, CSI/82-97. Note 109. No proclamation has been issued under Section 59. Again, no idea what that's in reference to without seeing the thing that they're citing for this notation. Note 110. Section 61 was added by the Constitution Amendment Proclamation of 1983, in brackets CSI/84-102. See also Section 3 of the Constitution Act of 1985, in brackets Representation. SC 1986 C8, Part 1, and the Constitution Amendment of 1987, in brackets Newfoundland Act, CSI/88-11. Okay, this brings us to the end of the notes section, which is the final section listed on the government's website of the Constitution of Canada. Thank you for joining us on this rather lengthy dive into constitutional law in our great country. Thank you, and have a wonderful evening.